Two medical marijuana companies walked up to a federal court and asked for one thing: a seat at the table to help defend the reform that made them legal. The group suing to kill that reform gave the judges an answer: keep them out of the courtroom. These companies can run their business. They just cannot help defend it in front of the judges. The reason the challengers gave for that is the part worth hearing. Start with the ground everyone is standing on. In April, Acting Attorney General Todd Blanche signed an order that moved FDA approved cannabis medicines and state licensed medical marijuana out of Schedule 1 and into Schedule 3. For an operator, that is the line between running a federal felony and running a regulated medicine. A coalition went to court to stop it. Three separate lawsuits, now bundled into one case, before the D.C. Circuit, the federal appeals court in Washington. The first from Smart Approaches to Marijuana and a national drug testing group. The second from a mix of anti marijuana activists, doctors, and a cannabis focused biopharma company. The third from three state attorneys general, though Louisiana later walked away. On the other side, defending the reform, stands the government, and only the government. Then, late last month, two companies did something unusual. Bud and Mary's, a medical operator in Iowa, and Tri Mountain Pure out of Pennsylvania. Both had already filed the federal registration form the DEA opened up for cannabis businesses once rescheduling began. Both asked the court to let them join the case on the government side to help defend the reform rather than attack it. Their argument was plain: if the challengers win, these companies get dragged back into Schedule 1, and they would be, in their words, directly harmed. The challengers moved to shut that door, and they leaned on a real rule of federal procedure. To join a case as a full party, you usually have to show that the people already in it will not adequately represent your interests. The government is already defending the reform. So, the challengers argued, the companies bring nothing new to the table. In their brief, they put it flatly: the proposed interveners, they wrote, have not identified any argument they would make that the government would not already press. The companies had in fact named a reason. Their stake is not the government's stake. Tax treatment under Section 280E, the rule that taxes cannabis businesses on their gross revenue, pending registration applications, banking, research, hiring. Real business consequences riding on the outcome of this case that no federal lawyer carries home at night. Here is how the challengers answered that list. They called it irrelevant. Commercial and operational grievances, they wrote, with nothing to do with the only question in the case. So why work this hard to keep two allies out of the government's own corner? Because a full party is not a spectator. A party can shape the record and can appeal a loss. A friend on the sidelines cannot. The government's position can move. Administrations change. A company with its license on the line fights for that license in a way a federal lawyer never has to. And notice who is making this argument: the same challengers whose own right to sue rests on money. A drug testing lobby worried about testing revenue. Commercial stakes are fine, it seems, when they are the ones holding them. The challengers did leave one door cracked. Let the companies file as friends of the court, they suggested, outside parties who hand up a brief and go home. A friend of the court can write a letter. It cannot question a witness. It cannot shape the record, and it cannot appeal. That is the whole distance between a seat at the table and a note slipped under the door. None of this is happening in a vacuum. This week, the DEA wrapped an administrative hearing on rescheduling, where the government's own witnesses laid out the medical uses and relative safety of cannabis, and the opponents attacked the process instead. In Congress, a House committee voted to block officials from spending money to carry the reform out, though lawmakers on both sides doubt that effort goes anywhere. And the lead lawsuit against rescheduling is being run by Torridon Law, the firm where William Barr, the former Attorney General, is a partner. The court will decide the intervention question in the coming weeks, well before it decides the case itself. And that smaller ruling tells you something the headlines will not. So here is what to actually watch. When the order comes down, look at one thing. Did the two companies get in as full parties, or did the court send them to the sidelines as friends of the court? Full parties means the industry defends itself directly and can appeal if the government ever softens. Sidelines means rescheduling gets defended by the government alone, and the industry has to trust that the government keeps fighting as hard as it does today. If you want to see which way that door swings, hit like and subscribe. The people who want it kept illegal are also fighting over who gets to be in the room. That tells you how close this is.